Welcome to You and the Law. I'm Steve Cilente.
And I'm Bob Lally.
Today, in response to a viewer's question, we're going to talk about grand juries, both civil and to some extent criminal grand juries. There's a lot of information, Bob, and I don't know that we'll get through it, but let's give it a try.
Okay.
First of all, generally in each year in California, all 58 counties have a group of ordinary citizens who take an oath to serve as a watchdog over various government operations.
Well,
and they're primarily interested in the effectiveness and efficiency of government operations in their county.
right. It's my understanding they examine county and city governments, school districts, joint powers of agencies, special districts, housing authorities, pretty much you name it. If it's an agency, they kind of check it out. Is that right?
Exactly. And under the California Constitution, and for those who are interested, Article 1, Section 23, every county is required to have a regular grand jury in place every year.
The rules governing the grand juries, they're located in the Penal Code, as I understand it. And if we get down to particulars, Penal Code Section 888 to 939.
Right. So the original grand jury requirement comes from the Constitution of California, but then the Penal Code lays out how everything is supposed to be done. And in some instances, a county can have an additional grand jury, but that's at the discretion of the presiding judge. I've never seen it in our local counties, however. Now,
I've never seen it either.
yeah. Now, historically, a lot of people don't realize that grand juries or some type of grand jury goes back to like 978 AD, where 12 leading citizens of the community be brought together, but they were primarily interested in crimes, and it went from there.
Well, it goes back to like Old England, as I understand it, because that's where our laws come from. I think, I'm not going to pronounce this right, but the Assizes, okay, of Northampton, I mean, going back to 76? Basically provided that anyone charged before the king for certain crimes like murder, theft, robbery, they had to be indicted, basically, what we call an indictment today, by a group of knights through a certain process. Am I right about that?
Well, they also did punishments as well. In other words, remember the trials by ordeal?
Yeah, well, that's some of my trials today. I call them ordeals, but yeah.
Under their trials by ordeal, they could lose a hand or a foot.
Well, that would be a bigger ordeal, yeah.
Yes, and I don't think any of your trials...
No, that has not happened in any of my trials,
right.
Thankfully.
And then there was a grand inquest, and there the sheriff would become involved, all of this in England. Mm-hmm. So the point being is that there is a historical development of the grand jury system that goes back centuries. And of course, like many things in California and the United States, our origins go back to California. But let's take a look at California civil grand juries regarding the makeup, organization, powers, of the grand jury as indicated by the California Penal Code.
Well, you're talking about recent changes in the Penal Code and the requirements. You mentioned the additional grand juries earlier, but when you talk about grand juries, we really only have one grand jury that deals with both. Am I right about that?
No.
Okay.
And we'll get to the criminal side a little bit later, but they generally are not the same. Now, grand juries typically in most counties run from July 1st until June 30th. And normally there are 19 people on a grand jury, and there can be more. It kind of, in some extent, up to the county or the judges what they want to have, and they go through an application and a screening process. They pick a jury foreman. The judges are actually doing the interviews, and in some counties they may actually carry over some grand jurors from one year to the next, just a handful, and until they come up with about 19 grand jurors. So there is a process that they go through every year.
Before we go on, each county sets their own guidelines on this because you don't have the same rules for grand juries and county by county?
The penal code dictates what they can and can't do, but is some discretion with the counties.
And it's my understanding that if you're fortunate enough to have the experience of serving as on a grand jury, and it's a privilege really, it's going to take about 20 hours a week, and you're not really going to get compensated for that, is my understanding. Am I right about that?
Well, they do receive token pay, and I don't know how much it is. Given today's budget, I don't know. But 20 hours a week, it depends on what they're doing, how extensive of an examination of a particular department or organization within the county that they are doing. And my guess is that some grand jurors would tell you it's probably more like 80 hours a week, but as an average, I'd say close to 20 hours a week. And this is why, in part, you see a lot of retired people who are on grand juries because they've got the time, whereas those of us that work 14 to 16 hours a week, it'd be kind of difficult to do.
Yeah.
So there we've got the civil grand jury. Now, criminal grand juries are a little bit different in that most counties, if there's a criminal grand jury, they select through the regular jury process and establish special grand juries whose job it is to listen to evidence from the district attorney and decide whether or not an indictment ought to be issued.
You're saying through that exact same process of like picking a jury?
Almost like picking a jury, except that it's all one-sided because defense does not partake in that.
And their function is to decide whether there are triable cases which should be brought by indictment, as I understand it.
That's correct. Now, originally, if there was a grand jury, it precluded there being a preliminary examination or preliminary hearing, which we're not going to really get into. But recent court decisions said that even if you go by way of grand jury, there has to be a preliminary hearing, just like a regular case would, which kind of took a lot of the thunder, as it were, out of having criminal grand juries.
We almost never see, I mean, locally, we just don't usually see an indictment by grand jury. It happens very rarely.
That's true. And normally, if there's a need for a criminal grand jury, it's a district attorney who asks for it, and through the courts. The courts assist in selecting the panelists and then you've got your grand jurors who selected. Mm-hmm. But again, no defense is involved. The DA is really not involved in the jury selection process. The DA is the only one that presents evidence. But because, as I indicated, anymore we see less and less of it. My understanding is in the Ng case that many people will recall, they did use a grand jury in that particular case, and that's where you typically see is the very high-profile cases. But it's kind of fallen out of favor anymore.
And once they have that indictment, what you're saying is the recent cases says that the people are entitled to a preliminary hearing in addition to the safeguard of the grand jury?
Yes.
That's interesting.
I thought so too when I found it.
Yeah.
But so the criminal grand jury, we're just going to leave there alone. We know that it exists. It can happen, but you don't see it very often. Most people are very, very familiar with the civil grand jury that we see published, as we'll get into, annually in our newspapers.
One area I seem to see that coming up a lot is where there's public agencies and public officers and their conduct
Right,
involved.
and that's what we're going to be talking about
Okay.
specifically now. Now, under the Penal Code, it requires that the grand jury inquire also into willful or corrupt misconduct in the office of a public officer of every description within the county. Now, this is a little bit different, okay?
I'm thinking of the word malfeasance. Where does that fit in there?
Exactly. Now, first of all, let me
Okay.
indicate that there are very few of these that are actually filed. You don't see this very often, but there are a number of areas that you can. Nonfeasance is one of those.
That could be the failure to act where a duty requires an act, or it could be negligent or refusal without sufficient cause or excuse to do something, or malice or willful neglect of duty.
Right.
This is a rather broad standard here that's subject to interpretation.
Exactly. And then we go from nonfeasance to misfeasance.
The improper doing an act that another person might lawfully do, the performance of duty or act that one ought to do or has a right to do, but in a manner such as to infringe upon the rights of others.
Right. So, got nonfeasance, misfeasance, then we have malfeasance.
The doing of an act that is positively unlawful or wrong, the performance of a wrongful act that the person has no legal right to do. I'm thinking that at some point, looking at these are broad standards that somebody could fit anything into.
What most often happens is when a grand jury gets involved in dealing with a public official where you've got nonfeasance, misfeasance, or malfeasance, the public officer, if there's any merit to it, resigns, and that pretty much ends the problem at that point. And certainly the district attorney on their own can investigate any of these things and criminally charge, in many circumstances, a public officer. So thereby bypassing a grand jury and dealing with those three things.
It's an interesting thought, but if you're still using the procedure of a preliminary hearing, which we've talked about in the other shows, and you have the grand jury, it's almost an investigative tool as opposed to a safeguard, maybe?
Yes, very much so. In using grand jury process, it is very much an investigative tool. In some ways, the district attorney gets a chance to see how evidence can be presented and how a jury might react to it. It's a little different than doing a regular jury trial that you and I are used to, either civil or criminal. It is different. And a little bit more interaction where the jurors can ask questions, ask to see certain evidence that perhaps may not be admissible in a regular jury setting. But we still see it very, very little anymore. The indictment process. What we typically see is the watchdog function of the grand juries whose reports we're looking at every year, where by state law they've got to look at doing annual examination for operations, accounts, and records of the officers, that's elected or county officers, departments, functions of the county, including any special district, like a water district, for instance, where the officers of the county are serving as ex officio officers of the district, and inquire into conditions and management into prisons, or in this case, in this county, into the county jail.
Hopefully, maybe we'll get a new one of those. But it's my understanding that the grand jury can investigate or inquire into county matters of civil concern, such as the needs of county officers, including the abolition of the creation of offices, equipment, like we're talking about, or buildings, like the county jail, for the method or system of performing the duties of the several offices, which would include the courts and the sheriff's office. The courts are a state office.
That's right. They can look at county, they can look at city, they can look at special districts, but when at the state level, that's a whole different ballgame, okay, and won't be included. One of the things that you're going to see in all of this is that it's a watchdog function only. they can make recommendations or suggestions, but as you'll learn, nobody has to follow them. All right? Now, there's a lot of power that the grand jurors have, whether it's a subcommittee of the grand jury or the actual grand jurors. They're permitted to have free access at reasonable times to public prisons or jails, county offices, county records, examine the books and records of any incorporated city, any joint powers agency, certain redevelopment agencies and housing authorities, special purpose assessing or taxing districts wholly or partly within the county, nonprofit organizations established or operated on behalf of a public entity. For instance, if it's a 501c3 that has nothing to do with the county, no. So
They also have the authority to investigate and report on operations and methods of performing duties, any such city or joint powers agency, and to make recommendations as to those. Again, whether they're followed is another thing, but they make the recommendations. The ability with the permission of the Superior Court to hire such experts as auditors, as accountants, the right to inquire into the sale, transfer, and ownership of lands which might or should go to the state. With the permission of the Superior Court. That's kind of interesting. How do you get the permission? How did they get the permission of the Superior Court?
the grand jury foreman does have contact with usually the presiding judge, and they do have a dialogue. In part, what can we do, not do, how far can we go? We'd like some money to do such and such. In today's budget, it may be a little hard to find some of these things, but it's all under the control or direction, I should say, of the Superior Court. The court doesn't really control it, except for perhaps saying, no, you can't go investigate some business that has nothing to do with the county. But one of the unique things, of course, is that while they've got certain duties to, under the penal code to do, they can also listen to or receive generally written citizen complaints as long as it involves the operations of county, city, or special districts within the county.
It's kind of interesting. It kind of goes back to the king hearing the complaints.
Except that it's a grand jury.
Right.
I don't think that the county supervisors have time to listen to all of the citizens' complaints, or certainly to conduct the type of investigations that the grand jury does. It's just not possible.
What are these like open hearings, or are they secretive, or?
As we'll learn, when they're conducting investigations, it is confidential. The eventual report that they do, there's a process, but it'll eventually become public.
But throughout the whole process, it's confidential. Is that like to all the subjects they might investigate, or?
Yes.
Okay.
Now, all of these investigations that they do conduct, remember the grand jury only has a term of 1 year. So the grand jury has to make a decision as to whether or not we've got the time to investigate something. Now, as I understand it, they can carry some things over for a year or so. But typically, most of their investigations are limited to 1 year.
Well, they have some mandated duties, as I understand it, and that's financial condition of the county condition of the county jails, and as you just have been going over, they have discretion in determining their agenda, and these things are mandatory, am I right?
They've got to be done every year. All right. Now, their report may be that everything is fine, I'm shortcutting it a little bit, but there are certain things that they have to do every year. They can't just pass it off or disregard it entirely. Now, most grand juries will actually divide themselves up into like subcommittees, 2 people or 1 person to investigate certain things, because they just don't have the time to do everything. Now, there is no set procedure to do that, and it varies from county to county as to how they want to actually conduct the investigation.
I just had a question, because like when we do a jury trial, whether in a civil we have a different standard than in a criminal, we have to have 12 people agree in a criminal, but usually I think it's a majority of 6 or something. In the civil, I can't remember off the top of my head because I'm thinking criminal right now. I don't know why. But do they have to have groups or numbers that agree in the grand jury to do something?
And we'll get to that.
Okay.
Okay, but
All
the
right.
short answer is yes.
Okay.
And it's mostly akin to the civil grand jury.
Okay.
Now, we talked about reporting very briefly. The law requires that each grand jury submit to the presiding judge of the Superior Court a final report of its findings and recommendations. Now, understand, if they start on July 1st, they've got to finish in July or June the 30th. That report has got to be submitted to the presiding judge before the end of their term, so they're really on a push. In addition to the mandated reports on financial audits and conditions of adult and juvenile detention facilities, some grand juries have covered topics such as deterioration of county roads, reserves amassed by special districts, hazardous waste disposal, misuse of funds, all kinds of different things as long as it's related to a government function.
Let's say they're going along and investigating a civil government function like this, but they uncover a criminal offense.
They can't do anything about it. Certainly they could report it to the DA, and it's up to the DA to exercise their discretion whether or not to take it. But once they've done their investigation, then they have to make a decision on what to do.
Well, and then
point.
they have to have groups like we were talking about earlier that approve it. For example, like an accusation or indictment must be approved by at least 12 of the 19 grand jurors, 15 if it's a 23-member grand
Right.
jury.
But on the civil side, you've still got to have a majority of people that are going to approve it. And I don't remember the exact split on the civil watchdog function, but I believe it is a majority only that have to approve it and sign off on it. But it is secret.
While it is secret, does the court have some function or safeguard procedure before they open it? Like the judge has to sign it, is my understanding. Superior Court judge has to sign it?
Yes,
That's the
correct.
presiding judge?
Both the foreman of the grand jury and the, it says probably most often the presiding judge, but we're talking about a county that only has 2 judges, so if one wasn't available, I'm sure that they would make some accommodation some way. But until it is signed, that publication doesn't go anywhere. The report doesn't go anywhere. But once it is, then all of the targeted agencies, those agencies that were investigated, interested public officials, private groups and individuals, and the press, then get a copy. Now, also, each year, the county heads who are targeted have an opportunity to respond or not.
But they're required by law to respond to the different reports. Am I correct about that?
Well, when I said or not, sometimes the responses don't really say a lot other than, yeah, we heard you, but we're not going to change it, all right?
Okay.
But there is some requirement that they have to. Now, some, I believe that they absolutely must respond. But again, even with these recommendations and a response, we have to remember the grand jury has absolutely no power to do anything. And the agencies are under no legal obligation whatsoever to carry out any recommendations of the grand jury. And a lot of these recommendations end up ignored, others may be followed, particularly those that may suggest a greater efficiency of operations and do not require the expenditure of a lot of money. They may or may not be accepted.
But we're really not talking about a lack of power in the grand jury, because we have public opinion today, and we have media, and the criticisms of public officials and agencies attract press attention, and they bring more community awareness and community pressure on these different agencies.
But they don't have any statutory or legal authority to do anything. Certainly, if you're running a county department and it came under fire from the grand jury because of different things that you're doing, public pressure is going to play a role. And of course, if you're holding that position at the pleasure of the county supervisors, you may find that it's their displeasure that's going to ask you to leave. But the grand jury itself can't say that you have to do such and such. All right, so they really have no power. It's the public. It is certainly the county supervisors that can take action if changes are not made.
Just curious, can they make a recommendation or can they go to a strong recommendation?
I think, like a lot of things, it's a matter of the choice of wording.
Okay.
Okay? Now, in the early days of our republic, grand jury was really the protector of the individual and kind of the conscience of the community. But as time has gone on and within the 20th century, now 21st century, it's become criticized as being archaic, inefficient, cumbersome, irresponsible, and costly.
Well, in 1933, it was abolished in England, and in the States, most of it has been severely weakened by other processes.
That's true. Although in California it appears to be going fairly strongly. Some of the major criticisms of the watchdog grand jury have been that their unrepresentativeness, they don't provide for good cross-section of the community. We've already talked about the amount of time that they require, and so that primarily a lot of retired people end up on grand juries, that they're reflective of community bias. While a grand jury may seek an impartial, or the judge may try to find an impartial grand jury, they're typically made up of people from local community, and they share the same prejudices of their little community area. So we don't have some of the big distinct lines that major cities may have, with certain segments of the population live in one area and different segments live in a different area. We don't have that as much here, but certainly I can see that. Irresponsibility is another area that, while the requirement for concurrence of 12 out of 19 members helps to control irresponsible actions, it's not a guarantee against runaway grand juries. Secrecy, a lot of people don't like the idea of shielding the public away from the scrutiny and independent reviews. A lot of people feel that everything about government needs to be open, and that's one of the criticisms. And certainly when it comes to looking at criminal grand juries, a lot of people see grand juries as a tool, or criminal grand juries, a tool of the district attorney's office.
But overall, isn't it possible to balance these criticisms with the argument that the California grand juries, especially in their watchdog role, offer an important service to the local citizens and volunteers of the oversight of public affairs?
I don't disagree. I certainly don't have time to be looking at county offices, and I certainly don't have access to the records and books and stuff of the various county officers to do what the grand jury does. And I'm glad personally that somebody is taking a look at what's going on in these different agencies, and particularly special districts, to make sure that they're doing what they're supposed to do and representing our citizens. And that's where the grand jury is very important.
And I don't think people really understand that when you talk about special districts, we have special districts that govern every area of the, and we even have cemetery districts.
That's correct. The grand jury system in Calaveras County, state of California, is a very important function that occurs every year in our county, in our area. It needs to be supported. It helps us all. Thank you for joining us today on You and the Law.